Okay, thank you so much once again, and good afternoon, everyone. I can see the text in the chat box. Good afternoon. So, good afternoon, distinguished guest, and I believe that our speakers on the call, and good afternoon, everybody, and all friends of, alternative dispute resolution and NICArb as a whole. So, today's webinar is a rather extraordinary one. Today is Thursday, right? And as we all know, FIFA World Cup 2026 is just kicking off. This is hosted across USA, Canada, and Mexico, and the whole world is watching currently. And in all of this, there are billions of dollars in commercial rights, sponsorship deals, and licensing agreements that have been, entered into by different people. And trust me, in each of those agreements, there is an arbitration clause. There are people who, have drafted these clauses. There are people who are going to also, stand up to represent whichever party when there is an issue. So that is why today's conversation matters, that as long as there is an industry, no matter how competitive it is, there will be a dispute resolution clause there. And the question today is not whether ADR is relevant, it is whether you are positioned to profit from it. And that is what today's webinar is all about. Our theme is from practice to profit, positioning yourself for ADR opportunity. And we'll be listening to distinguished speakers today who would help us with a roadmap on how to position ourselves properly to benefit from this. And to open this webinar, it's my pleasure to welcome the Registrar of and CEO of the Nigerian Institute of Chartered Arbitrators. She is a distinguished fellow, a chartered arbitrator, and the driving force behind today's gathering. Please join me in welcoming Mrs. Shola Oshodi-John, FCArb, to give us the opening remarks for this webinar.
Thank you, Chidera. Good day, everyone. May I, at this junction, acknowledge the presence of my lords, senior advocates of Nigeria, distinguished speakers, our colleagues, ladies and gentlemen, to today's webinar titled Practice to Profit. It is my distinguished pleasure to welcome you to this webinar. And this webinar today captures a very important reality in our times. Arbitration and ADR, that they are no longer viewed as just alternatives to litigation, but they have become very integral components of today's modern commerce, investment, and access to justice. And so with the theme for today, Practice to Profit, I know a lot of us are looking out, trying to understand how can we make profits as arbitrators, as counsels, expert witness, and all the other professions that come under the arbitration and ADR space. So let me say that when we talk about today's topic, Practice to Profit, it's not just about financial terms or profitability, but we're talking about profit in terms of creating value, expanding influence, developing expertise, and contributing meaningfully to the economic development and administration of justice. So basically, it is about transforming knowledge, building impacts, and professional excellence at every opportunities that we have. So I believe that today's webinar is going to provide us with the opportunity to learn from experienced arbitrators, experienced practitioners, exchange ideas, as well as explore, strategies that will help each of us to build a successful and a thriving career in the arbitration and ADR space. So I want to encourage all participants to please participate, ask your questions, and also view this section from the very beginning as a very as an opportunity for you to create new partnerships, as well as negotiate, network, and all the possibilities that are available to you. So on behalf of NICArb, I want to sincerely thank our distinguished panelists and speakers for today sharing their knowledge ahead, and all the participants that are going to be with us today. I am very sure that this very timely and important conversation will be one that each and every one of us is going to leave with some form of knowledge, some form of skills and understanding of how we can build our arbitration practice from just being a young practitioner to now becoming an experienced practitioner that is able to sustain the business, as well as even decide to say, all I want to do is just practice arbitration and ADR. So thank you, and I turn over the floor to Chidera.
Thank you very much, Mrs. Oshodi-John. You've mentioned all the right things, and I'm sure that everyone here is eager to hear from our distinguished speakers. So, my name is Chidera Ezenwanne, and I will be moderating this session. And my job here is not just to facilitate, discussion today, but I'm also going to ensure that everyone here leaves with practical insights that we can begin implementing immediately. And without further ado, just to introduce our speakers and also speak to their bios briefly. We have the immense pleasure of welcoming Mr. Adebayo Adenipekun SAN, FCArb, and Mr. Dapo Akinosun SAN, as well as Dr. Ifeoma Nwafor. And to read out their bios, I'll begin with the learned silk. Sorry, just a second. Yes, Mr. Adebayo Adenipekun SAN, FCArb. He's a senior partner at Ifeoma and Co. He's a distinguished litigator and an arbitrator with an outstanding expertise that spans different areas, including company and commercial law, land and property matters, international law, election petitions, and appeals. With over 3 years of noteworthy experience as an accomplished arbitrator, he has represented clients in numerous sensitive and high-profile legal suits at all levels of the Nigerian court system. He has also acted as counsel, sole arbitrator, and chairman in numerous proceedings for a wide range of clients, including the federal government of Nigeria, multinationals, leading corporate state governments, as well as high net worth individuals. Having been called to the Nigerian bar in 1991, the learned silk has consistently showcased his ability to navigate complex legal challenges and deliver favorable outcomes for his clients. He rose to the pinnacle of his profession in 2005 when he was awarded the distinguished silk title of Senior Advocate of Nigeria, the Nigeria equivalent of a King's Counsel. And at Ifeoma and Co., learned silk oversees the activities of all lawyers in chambers, ensuring the highest standard of legal service across the firm. One of his recent notable experiences include acting as counsel to the federal government of Nigeria in a second investment dispute arbitration before the International Center for Settlement of Disputes, Washington, D.C., United States of America. Acting as counsel to NNPC at an international ad hoc arbitration with an oil company, and successfully defending the federal government of Nigeria at the investment dispute arbitration before the International Center for ICSID, Washington, D.C. as well. And his profile spans more than this, but because of time, this is what we're able to read out. And today, the learned silk will be speaking to us on a presentation titled Strategic Positioning for High-Value Arbitration Practice in a Competitive Global Market. And if learned silk is here, we are ready to listen to you, sir.
Okay. I'm here.
Okay, thank you very much, sir, and good afternoon once again.
Yes, good afternoon, my Lord, learned silk, colleagues, ladies and gentlemen. It's my pleasure to be here this afternoon. I'm just going to discuss from my own experience, and I believe you'll be able to benefit fully. But I took interest in arbitration about 30 years ago. Just by accident, I followed my boss. I was not the one assigned to follow him, but one way or the other, it was my duty to follow him to an arbitration before the late Justice Kayode Esho. That was my first exposure to arbitration. When I got there, the environment was different from what I was used to in the traditional litigation. And I became so interested, very cordial, peaceful, not rancorous like the other dispute resolution mechanism, which is the traditional one. And since then, I've developed interest. But one question that came to my mind, which that was why I commend the organizers of this webinar, was after learning the rudimentary of arbitration, practice, law, and everything, how do I get brief? How do I get exposed? How do I get experience and all sort of? So the first thing I want to talk about is the need for us to acquire the knowledge. So that's the first requirement. Arbitration is not done like it is done in other aspects where you can make mistake, correct yourself, or people give you brief, not finding out whether you know or you don't know. But in arbitration, if you don't have the knowledge, it will be quickly obvious, and that may be your first and the last brief. Because you are appearing before seasoned arbitrators, and once you fumble and you don't do anything worthwhile, you can be sure that when next your name is mentioned, might be there 1 or 2% will say, I don't go to that person. So that's why the first thing is to acquire knowledge, train yourself very well. And then how do you train yourself? Good enough, during the time they were coming up, we didn't have many institutes, associations as we do have today. But today we have a number of them. Nigerian Institute of Chartered Arbitrators is outstanding in training, in learning, in certification. So you need to get yourself well educated, practice law and procedure. For lawyers, it's even problematic for them because you can't carry the knowledge you acquire in traditional litigation to arbitration. Completely two different things. So you have to humble yourself and learn the rudimentary of arbitration. If you think you can come into arbitration because you are a lawyer called to the bar or you have been practicing law for many years, you will be embarrassed by the time you find yourself in problem. I remember one day when the first international arbitration where I attended was in France. It was the preliminary meeting. So, in Nigeria court system or whatever, first day of the proceeding, you think they just go there and just one way or the other. But good enough, I was prepared. I made sure that everything was in place. We were there for 7 to 8 hours. It was a different ball game entirely. The whole thing went on and on and on and on, and everything we needed to do for the entire arbitration proceeding highlighted that same day. So it's not a question of, okay, this case is for mention today, so we'll just take a date and go away. It doesn't happen in arbitration. So when you ensure that you have got enough knowledge, what next do you do? Then pupillage. You need to also make sure that you study under those who are experienced arbitrators and ensure that you get the experience. And that is the idea of mentorship. I'm happy that Nigerian Institute of Chartered Arbitrators have those programs around. Get yourself a mentor and then take your time to study under someone who is well experienced. When you get that, that will be fine. Then some people say, okay, I've done all those, but see, I haven't got anywhere. There are other things you need to do. You need to make sure that you attend conferences, seminars, like this one we are doing here. I remember in 2018, we were in Rwanda for the conference of African Arbitration Association. And one young lady raised up her hand and said, how do we get ourselves exposed and also get briefs in arbitration? And I remember one of the panelists who answered that question. So one of those things is the panelist said, which I still remember vividly, is that you attend conferences. When you attend conferences, don't just be a passive observer, be an active one. And how can you be an active one? Well, you are not a speaker, you are not a panelist, you are not scheduled in the program. You can go to the organizer and say, please, can I help you roll the microphone? Can I help you distribute papers? Can I help you pass this, pass that? You'll be surprised while passing the microphone, while passing the paper, or while doing all those things you consider menial activities, people will notice you. And so when during break time, lunch time, your face will be familiar to many of the attendees there, and they may be asking you questions. Oh, what's your name? Where are you from? This, and then by the time they share their cards with you, one day they may be looking for someone who should be registered. Oh, I remember that young lady who was in the conference where I attended. We just look for your name and address and then be invited. So that is also very important. Then, if you are the type that can write articles, make sure you write articles talking about arbitration, talking about contemporary issues in arbitration. Very, very important. And if you are really interested, if you are the type, academic type, you can even write a book in arbitration, on arbitration. I also give an experience. In 1999, I was going to China with my boss, and at the Lagos airport, we met the late Professor Ajoma. And my boss asked him, where are you going to? And he said he was going to Singapore. And my boss said, to do what? He said, on arbitration. And my boss said, Singapore, you? How do you get an appointment to sit on arbitration in Singapore? And he said he was also surprised. They said they read his book. And because they read his book, that was why he was invited. So you can see publication, writing articles, contributing to conference activities. These are things that will grant you opportunity to transform from just making money or having experience in arbitration. So these are areas that you need to touch and want to touch upon to start with in order to get yourself positioned and that for profitability in the practice of arbitration. Thank you very much.
Thank you very much, Leonard Siok. That was very, very succinct and quite packed. I mean, you've mentioned that there is need to, be knowledgeable. You cannot say you want to make money from arbitration without actually knowing, what it entails or how to navigate it in case you have to represent a client or something. And there's also the need to attend conferences and networking like you have mentioned, and the need to also have publications. And I'm sure that a couple of people have questions. So just to mention that if you have any questions, kindly put your questions in the chat box, and we will attend to them later. And I saw that a couple of people had mentioned that the audio was quite low. If you know that this is better, just do a thumbs up, and we'll be sure that you can hear us clearly and everything is moving fine. Thank you so much again, Leonard Siok, for that. And we'll be moving quickly to the second speaker today. Okay, thank you. I can see the thumbs up coming up. We're moving quickly to the second speaker for today's session, who is Mr. Dapo Akinosun. Sorry. Yes, who is Mr. Dapo Akinosun, SAN, and I'll be reading out his brief biography. Mr. Dapo Akinosun SAN is a founding and senior partner at Simmons Cooper Partners. His legal expertise spans across multiple sectors, including gas, banking and finance, energy, aviation, capital markets, infrastructure, maritime and shipping, and project finance. He has contributed to legal scholarship, particularly in the oil and gas sector. His notable works include the article Potential Effects of the PIB 2012 on Existing and Future Business Arrangements in Nigeria's Oil and Gas Industry, The Legal Perspective, published in Energy Today, and co-authoring the book Understanding Natural Gas, A Nigerian Perspective. He's a member of several professional associations, the Body of Senior Advocates of Nigeria, the International Bar Association, the Nigerian Bar Association, amongst others. And he'll be speaking to us today on From Legal Practice to Profitability, Building Authority and Sustaining Success in Arbitration. Please welcome Mr. Dapo Akinosun SAN.
Good afternoon, everybody. I hope I'm a bit audible.
Loud and clear.
The distinguished chairman, fellow arbitrators, and ladies and gentlemen, my dear learned brother Silk, Adebayo, Adenipekun, I think you have put me in trouble, first of all, by asking me to speak after the learned Silk. With his own wealth of experience, I guess I may not have much to say after that. But let me begin with a quick confession. When I was a young lawyer, or when I was a younger lawyer, because I believe I'm still young, I thought that if I worked hard, knew my law, and won all the cases, clients would begin to look for me and I would not have to do any marketing. After all, that is what they told us in law school, that we should not even market. But reality soon introduced itself to me. I discovered that legal profession is like a little beautiful restaurant hidden in the middle of Oshodi market. The food may be excellent, but if nobody knows where, nobody will come to you. And I believe that is the same of arbitration. Many brilliant lawyers never build a thriving arbitration practice because they lack, not because they lack competence, but because they have not positioned themselves strategically. And today, I want us to discuss a simple but also important question. How do you become a person people think about when a major arbitration arises? Why will people come to you? Because it is not enough in arbitration just to be competent. The market must know that you are competent. When I was called to the bar in 1991, arbitration did not enjoy the prominence it does today. Now it has become a global thing. And I've seen a dispute which involved a Nigerian company. It was governed by English law. The one that Professor Jegede, my first employer, was going to, the seat was in Singapore. And today you can hear virtually by arbitrators in 3 different continents. And it is funded by an investor sitting somewhere in New York. So when you look at the structure of arbitration today, you wonder whether the dispute itself has a passport. And reality is that arbitration has become international, sophisticated, and highly competitive. And no one can build a successful arbitration practice by accident. And one of the things, or I will start by saying the steps or the things we need to learn or lessons from it. The first thing is that you should stop trying to be everything. One of the biggest mistakes young practitioners make is attempting to be everything at the same time. You are the construction expert, you are the oil and gas expert, you are the maritime expert, you are the technology expert, sports arbitration, you're an expert, election petition expert. And before long, you're expert in everything apart from getting appointed. And the market in arbitration only rewards specialists. If I have $1 billion LNG dispute, I will naturally look for someone who understands LNG projects. If I have a shipping dispute, I will look for someone who understands ships and not someone who just saw a ship on third mainland bridge. The truth is simple, as my learned brother said earlier on. Arbitration expertise is important. Industry expertise is also important. But the sweet spot is where your arbitration expert meets industry expertise, and then you will get high value work. But to remain in the sector and get good work, you must choose a sector, study that sector. As I said, write about it, speak about it, live it. Eventually, the market will begin to associate with your name in that field. And when that happens is when opportunities will begin to come up. A second thing you need to understand that we need to follow in this industry is that reputation is the real currency. It is not your business card. It is not your office furniture. It is not your silk. It is your reputation. Every email, every appearance, every submission, and every interaction is an audition for your future engagement. People are watching you however you do. Clients are watching, colleagues are watching, institutions are watching you. Remark about arbitration is that it is a small community. I remember when I was just trying to get into arbitration, I used to get offended and say, oh, it is just a cult. It is only the people there that know themselves. You can't get jobs there. But you may think nobody is noticing your conduct, but trust me, somebody is noticing. A senior arbitrator once said some time ago, he said, it takes 20 years to build a reputation and 20 minutes to destroy it. And I found that observation to be very accurate. As a practitioner, you need to protect your reputation. It is your most valuable asset. A third thing, like the learned Silk said earlier, is that you have to be visible. Many lawyers do excellent work, but they do it quietly. So quietly that nobody even knows that you exist. Visibility matters. Write articles, publish papers, speak at conferences, join professional discussions, teach others, mentor others, share the knowledge you have. And I often tell you that if you write enough articles, somebody somewhere will begin to notice you. And visibility is what creates your opportunity. Most appointments don't come just because somebody searched the internet. There must be someone who remembered your name or read your article. As I said, someone read Professor Jegere's book and called him from Singapore. Somebody will read your recommendation, and then they will trust you and recommend you to somebody else. A fourth point I think we should go away with here is that you should go where appointments are made. Appointments come through institutions, so you need to join professional bodies. You need to attend conferences. As my brother said earlier, you need to volunteer, accept committee assignments, seek panel appointments. Don't just be a quiet participant, but participate actively. Don't just be, I paid your annual subscription and you go to sleep. No. It's a community. You have to be seen regularly, and one recommendation leads to another, and that is how the careers go. The second to the last thing I believe we should learn as I begin to wind down is that you need to work across cultures. There are different cultures. As we go international, different cultures will communicate differently. Different lawyers negotiate differently. And as an arbitrator, you need to manage proceedings across cultures. In some cultures, you will find out silence means agreement. In other cultures, silence means disagreement. But in arbitration, silence often means that the witness has not understood your question. Cross-border competence is therefore more important than just understanding the legal system. It is understanding people across cultures. And the lawyer who understands people often gains advantage over the lawyer who merely understands procedure. I do remember how in my early days as a lawyer, I have a friend, a very good lawyer. When it comes to understanding practice and civil procedure, is fantastic. He knew how to use the rules, but he didn't know how to settle and close cases. After you've gotten the orders, there comes a time you need to speak and negotiate. But that wasn't his strong point, and it did affect his practice. Lastly, technology is no longer optional in arbitration. At the conference today, everybody talks about AI. Sometimes I have wondered if Moses was coming down from Mount Sinai today, somebody would have asked him whether the tablets were generated by AI, that were this generated by AI, or how did you get it? But jokes aside, technology is transforming arbitration. Document review, research, case management, virtual hearings, translation, data analysis, all these are becoming faster and more efficient. A lawyer who ignores technology today risks becoming professionally obsolete tomorrow. However, technology should just remain a tool for us, not a substitute for judgment. Artificial intelligence can identify authorities, but it cannot replace wisdom. It can review documents, but it cannot replace experience. And thankfully, at least for now, it cannot cross-examine a dishonest. You need your witness, you still need your own intelligence to be able to do that and identify that quickly. So, ladies and gentlemen, the practitioners who will build successful arbitration practices are rarely the most fortunate, but they are the most deliberate. They develop expertise, they build reputation, they create visibility, and they engage institutions to cultivate relationships and engage and embrace technology. Most importantly, they remain consistent. Positioning for success is not an event. It is a process. It is something that you do often and again and not just once. The good news is that every practitioner in this room today can begin that process immediately. The market for arbitration will continue to grow. Opportunities will expand. And the question is not whether the opportunities exist. It is whether the market will think of you when the opportunities come. Ladies and gentlemen, this is a true challenge of strategic positioning. Thank you for the opportunity to speak, and I hope you go home with one or two things that you can use again. Thank you.
Thank you so much, Leonard Silk. Thank you so much. That was really insightful and very packed. I mean, just to reiterate that, Leonard Silk had mentioned that there is room for everyone in arbitration. Just know how to position yourself in the rooms where these decisions are made. I would mention again that if you have questions, you can drop your questions in the chat box. Immediately after the last speaker speaks, we'll take questions so that the Leonard Silk and our speakers can also speak to this. So if you have any questions, please drop them in the chat box or you can send them to me. And moving straight to the our third speaker today, our third speaker is Dr. Ifeoma Nwafor. She's a cyber policy expert and a principal partner at IEN Legal Associates with over 15 years of experience. She holds a PhD in cyber law from the University of Nigeria, where she graduated with distinction. She's a lecturer in law at Godfrey Okoye University, Nigeria, and a European Union Erasmus Scholar, Germany. She has written and continues to write extensively in the cyber field and has authored several peer-reviewed publications in reputable international journals. Her latest book is entitled Cybercrime and the Law, Issues and Developments in Nigeria. She was a finalist Women in Cybersecurity Awards Africa 2020. She's a member of several regional and international organizations and committees, including UNODC Africa Women in Cyber Network Group, the Governing Council of Digital Rights Lawyers Initiatives, the African Women in Security Network, and the Cybersecurity Experts Association of Nigeria. Dr. Nwafor is passionate about bridging the gender gap in the cyber field and empowering women generally. Please welcome Dr. Ifeoma Nwafor as she speaks to us on unlocking ADR opportunities, visibility, influence, and career advancement. Dr. Nwafor, please.
Good afternoon, distinguished Chairman Leonard Silks and colleagues. Like the Leonard Silks said, I also feel troubled because speaking after them, they've said so much, but I have to play my role, what I've been assigned to do today. So I'll be speaking on the importance of visibility in creating ADR opportunities. But I'll say first things first, I would like to explain visibility in the context of today's webinar. So visibility means being known and recognized in the ADR circle or marketplace by those who need to select or appoint mediators, arbitrators, negotiators, or other ADR practitioners for disputes. So aspects of visibility include being findable, accessible, and recognized. So an ADR practitioner is findable when parties or prospective clients can locate through an ADR directly, professional networks, or websites. So visibility is critical in creating ADR.
Come to my office now.
Because ADR related matters are highly competitive.
Sorry, I think Dr. Nwafor has been muted. Please, if you're not speaking, kindly mute so that we don't have to mute everyone. And I think this has affected Dr. Nwafor. Okay.
Okay, I don't know.
Continue.
Start afresh or...
No, you may continue from where you stopped, ma'am.
Awesome. So I was talking about visibility in the context of today's webinar, that visibility means that you're findable and you're accessible. You're recognized by the ADR related institutions or bodies that, usually appoint ADR practitioners. So visibility is critical in creating ADR opportunities because ADR related matters are highly competitive, like I said. So, and there are more ADR practitioners than, the jobs. So to be able to secure appointments as an arbitrator or mediator, you have to be visible, which means that your value, impact, and expertise are recognized, but you must also be findable and accessible. Parties and institutions selecting ADR practitioners rely heavily on reputation and recognition and not just conflict resolution skills. So I'll speak to practical steps that young ADR practitioners can take to increase their visibility and establish strong professional presence in the field. So ADR practitioners can build visibility by one, updating your profile with the ADR institution you belong to. So I believe all of us here are members of the Nigerian Institute of Chartered Arbitrators. So if you're a member, you're a fellow and associate, you can increase your visibility in the field by making sure that your data with the Institute's website is up to date. So prospective clients, organizations looking to partner with or appoint an ADR professional usually consults an ADR institution's website to find practitioners to appoint for an arbitration role or a mediation role. So ensure that the listings in the ADR databases are up to date. So if a prospective client visits the Institute's website and clicks on the Find Our Members section, would your name be in the NICArb Institute's website? So after this webinar, if your profile is not updated, it's not up to date, please reach out to the appropriate body of the Institute and make sure you have an up-to-date profile in the NICArb website. So as we say in Nigeria, charity begins at home. it is important to be active in your local branch and by extension, the national branch of the Institute. So to the best of my knowledge, and I believe the Institute has branches, depending on where you're based, right? So if there's an Enugu branch of NICArb, there's the Lagos branch, there is the Port Harcourt branch, there's the Kano branch. So you can take up leadership roles or volunteering roles in the local branch that you belong to. This usually builds visibility. So volunteering demonstrates that you are team-oriented and that your service focus, and others see you as someone who contributes to the professional growth, right? Then in leadership and volunteering roles, you attend meetings, you serve on committees, you participate in events, and you are put in regular contact with established practitioners. So you build relationship while working on projects, and these connections can lead to visibility, it can lead to referrals, and it can lead to ADR opportunities and mentorship relationship. So like the Leonard Silks had already said, attending conferences, speaking at webinars like this helps build visibility. Once you've spoken in a conference, most times people tend to remember you, and when an appointment comes up, you're easily findable and accessible in the sense that they now maybe have your contact, they can look you up on LinkedIn quickly and definitely reach out to you. And when you attend conferences, don't just hand out your business card, right? I would say spark a conversation with other attendees, make that conversation a memorable one so that you're not easily forgotten, because people collect business cards in conferences and trust me, they just dash it somewhere. But when you have a conversation that was memorable, most times the person you had such conversation with would always remember you, or when your name is mentioned, it kind of rings a bell. So offer to speak in ADR conferences, bar association, and other legal industry-based conferences and events. Write articles, blog posts, write a book, like the Leonard Silk had already said. Then something I also want to speak to is build a referral relationship with other ADR practitioners in the industry. So step one is to find the right practitioner to connect with, right? So like the Leonard Silk said, you can be jack of all trades and master of none, meaning that you're known for you specialize in commercial, arbitration, construction, maritime, sports, and then it's hard for someone to say that this is your area of expertise. So when I talk about building a referral relationship, it's where you have a mutual referral relationship, in the sense that you reach out to other ADR arbitrators that are have a different specialty from what you are known for. I'll give a good example. If you have expertise in construction, arbitration, you've undergone trainings, you can speak to it. Everyone knows that this is your area of expertise. You can build a mutual referral relationship with someone that is an expert in maritime arbitration. So when you get an appointment, and because we have ethical values in, the arbitration industry, and you don't have competence in that field, you let your clients know, oh, I can't do justice to this particular appointment, but I can refer someone that I know that has expertise in this field. So this is more of people getting jobs, but you're doing the right thing ethically because you are referring someone that actually has expertise for that job. And trust me, your clients, the arbitration institution that might have appointed you, would see you as someone that is credible, someone that is, fair and understands how it works. And it's not just about the money, picking the job and going to learn, that particular field. So referral relationship is also important. Then another thing I would say is engaging in professional conversations, maybe on LinkedIn, on the industry-based conferences and all of that. I don't know how much time I have, but I have a couple of other things to state. I'll just quickly round off. So also, like the Leonard Silk said, the world is going digital, so you have to leverage on technology. Use social media platforms, but please use them correctly. everyone, I believe it's important to have like a LinkedIn, profile. Have your LinkedIn profile updated. Trust me, LinkedIn is a good platform that helps build visibility and career advancement if you use it properly, right? So consistency and professionalism are key. ADR professionals should at least maintain one social media platform that they use well. Please remember that the internet never forgets. I find it weird when I see legal practitioners arguing on social media platforms, saying things that, so you have to be careful because careless posts can also undermine your trust and credibility. So social media posts should be accurate, thoughtful, and aligned with professional standards. Another thing I would say is your digital presence. Trust me, once your name is mentioned in a room for an appointment and the person does not know you, the first thing they do, like they say, is Google is your friend. The first thing the person does is go online to check your profile. So it's important that you have your own personal website or that your profile is updated in your law firm's website, right? And your profile has your credentials, it has your niche area, and it has maybe a professional photograph. Because once your name is mentioned in a room, what the person does is to quickly, check you, look you up on the internet. And it's important that whatever pops out is something that speaks highly of you. Then professionals seeking long-term success in ADR, there are things that you should leverage on. Sector-specific trainings to gain, subject matter expertise. You have to invest in yourself. You can't say I've gotten to the peak of my career and I don't need further trainings. No, you attend webinars, you attend conferences, you attend trainings. You spend money to actually make money, right? So also seek experienced mentors and also mentor new practitioners. I have a good number of mentors. I also have mentees. So when you're gaining from mentors, you should also give back to the society, right? Which means that you have people that you're also mentoring. So there are several leaders with many years ADR experience who have excelled with their arbitration careers, and they can serve as mentors. An email, you could politely ask them to be mentored, or you go to a conference, you can reach out to these leaders in the arbitration sector and humbly ask to be mentored. Also master your craft. Anytime you get an appointment as an arbitrator, for instance, or a mediator, please make sure you exhibit competency, you exhibit professionalism and candor, because these are the things that would get you more referrals and more jobs in the future. Also build credibility. Credibility will get you, it will get ADR experts repeat appointments, referrals, and all of this, and invest in continuous learning. Thank you.
Thank you very much, Dr. Nwafor. I mean, across all of the speeches or the presentations that we've heard today and from yours as well, something has been mentioned specifically, the need to master your craft, and it's something that is non-negotiable. And also, you need to be a part of an institution. If you cannot say you are interested in arbitration and nobody has your record anywhere in any, arbitration institute in the country or overseas. Thank you very much, Dr. Nwafor. And I have a question here. We're now in the question and answer segment. I have a question here for the panelists. And this question I'd like to ask is, so the question I have here with me, first of all, is if you were starting your ADR career again today, what would you do differently? Someone sent this to me privately, and I'd like speakers today to please answer this question. Dr. Nwafor, I don't know if you mind answering this.
Okay, you said the question is if I'm starting
your ADR career again today, like afresh, what would you do differently?
Okay, my own story is I don't think I'll do anything differently because I think I've been opportuned, if I want to be very honest. So I did my first associateship training in 2006, straight out of law school. That was 20 years ago. So once I was called to bar, I was called to the bar. After a couple of months, I did the training with NICArb, and then it took me a good number of years. Okay, so maybe what I would have done differently is I would have put myself out there. But in 2006, I was based in Enugu State, Nigeria, so there weren't a lot of arbitration jobs at that point, but I'd always been very passionate of arbitration, and I was willing to do these jobs for free. That was how much I loved arbitration. So once I got my first appointment as a registrar, and I was, like I said, I was willing to do it, for free. And someone I knew that got, her first job as a registrar said she was paid 50,000 naira. So I was thinking my registrar's fee would be in that, bracket. And then when I saw my email, in fact, my jaw dropped as a registrar. That was in 2016. My fee was 2 million, right? And that was what made me, I was like, no, you know what? I am going to invest in continuous learning. And then I went and did the fellowship training. And when I went for the fellowship training, I was humbled because it was, you had justices of various courts in Nigeria, senior advocates of Nigeria. So I was like I hadn't done my PhD, so I just had the Mrs. in my name, and all of that. So long story short, did the fellowship training, won the overall best candidate for the fellowship training. That was in 2017, and won the Are Afe Babala's prize. So I think it opened doors for me. So that's why I would say my story might be different from someone else's story because I feel I've been opportuned by God's grace. I'm not there yet, but at least, I've been trying my best in the industry. So, but like I've said previously, and to answer this question, I would just say, just try to be visible, volunteer in your local branch, participate with NICArb, make sure your profile is updated. And another thing you could also do is after your trainings, let your clients know that, you've added another credential to your file, meaning that you're now an expert in this field, and then encourage clients to always have arbitration clauses in their contracts. Thank you.
Thank you very much. I think that is very practical and relatable. Leonard Silks, I don't know if anyone wants to contribute to these questions, or do I just move to the next question?
I was waiting for my brother's sake, Dapo, to respond because I know he will have something to say, but he wants to come last this time around. So let me say something. What I would have done differently? Very difficult answer. Dr. Nwafor tried to answer it, and it was not easy. Same thing with me. But perhaps I would have started my practice in Lagos or Abuja, close to the commercial center. But that is no longer relevant because of technology. The whole world is connected now technologically, and what people in Lagos are doing, people in Ibadan, Enugu, or anywhere are also doing. But at the time we started practice, it mattered a lot where you were practicing. Those in Lagos had advantage over those outside Lagos. So that affected my practice a bit, especially in arbitration. But the another thing is that if I started in Lagos, I would never have known Are Afe Babalola anyway. And that would also negatively affected my practice. So I'm confused. I don't know whether I would have wanted to do anything differently. But where you start your practice matters a lot. Maybe that would have been a major consideration.
Thank you very much, Leonard. So, yeah. And just to ask the next question, and then it's someone has also asked that, is it possible to build a full-time ADR career without traditional litigation practice?
Is that for me or for my colleagues?
For you, Lenecio.
Okay. Well, I'm sure that's it's related to the question we just answered. It's very much possible. Very much possible. Between 2000, before 2011, I was basically combining election petition and arbitration. But after 2011, I concentrated on arbitration and stopped handling election petition. And I have no regrets. From my experiences then, I believe it is possible to concentrate on build a full law practice on arbitration mediation. And that will lead me to what my brother Sikh mentioned earlier. That is specialization. Specialization is very important. Initially, as a young lawyer, it might be difficult because you are thinking of how to make ends meet. If I specialize in sport arbitration and somebody comes with land matter, what will I do? Am I not going to eat? That can happen. But once you specialize in an area, you might be doing some other practice underground, but let people know you with that area of specialization. So my answer is that you can build a full law practice specializing in arbitration. It's possible, and we have a few chambers in the country today that are majorly doing arbitration. They're not doing any other thing. This is possible, please.
Thank you very much, Lenecio. Mr. Dapo Akinosun, I don't know if you can still hear us and if you'd like to contribute to any of the questions so far. Oh, okay, I can see you now.
The question is, what else can I say, or what more can I add? After the erudite doctor has spoken and the learned silk has also spoken. But what I would do differently, I think I started on a very rough note, because when I left, law was my second degree. I'd done a first degree in history. I'd worked for some time in civil service before I started law. By the time I finished law career, I felt I was late. I was old. I needed money. So I in a law firm before I left and went to the finance industry. So my foundation was staggered for pursuing money at the same time, trying to get into law practice. So I would stay steady now in law practice and concentrate on what I'm doing, because that cost me time in getting back into practice. However, on the other hand, when you talk about special, it gave me a broad base, because I now had friends in the finance industry, which helped me to build my practice when I was coming out. But on the other hand, when you are not specialized and you are jumping to and fro, I found that I could not really litigate or finish cases well. I was forced into ADR because it was better and easier for me to negotiate a settlement anyway than to pursue litigation all the way. So I would have concentrated on that line all the way rather than jumping back and forth. But is it possible to build a full-time career? Maybe at that time it was difficult, because even it was difficult to find in the 1990s a law firm that just said all they were doing is solicitor's practice. You had to go to court. Most people were solicitors and advocates. But today, there are enough braves that are going out. You find law firms that survive. But then practice was not so well defined. But of course, today you can do that and say, I'm not going to court at all. And I see a lot of young people who don't do litigation at all now, who are doing very, very well. So yes, you can build it on sole ADR practice today. Thank you.
Thank you very much, Lenesu. Lenesu, just one more question that we have here. Someone is asking, what practical steps should a law student or young lawyer take to become a competent and respected arbitrator in Nigeria, particularly in light of the evolving arbitration landscape under the AMA 2023?
Is that for me?
Yes, Lenesu. Yes.
What can you do now?
Yes.
Concentrate early, specialize early, find mentors. If you find a mentor, and you see a lot of people say, I want you to mentor me, but they don't look for their mentors. I am a busy person, and I'm sure for you to want me to mentor you, I must be doing something right that you see in me that you want to emulate. So if you are going to find a mentor, you need to find your mentor and follow your mentor. It is not the mentor that will be looking for you. But if you are serious about a mentor, you will find that staying with that mentor will help you grow in that area. Just look at someone you like in that industry. Look at the thing. Sometimes you may not like everything about your mentor. Take the good, leave the bad. But have someone that is a leader, someone that you look up to. And that way, it will teach you the rudiments, and it makes it a lot easier. What you read in the book is good, but what you read and learn from people, you even do it faster. Thank you.
Thank you very much, Leonard Seo. Thank you so much for that. There is one more question here. Dr. Nwafor, I don't know if you can help us, answer this question. It's from a law student as well. It says, my question is on the issue of developing knowledge and expertise in arbitration. I would love to know how one gets acclimatized with the procedural aspects of ADR, particularly arbitration. For instance, drafting written submissions, notice of submission to arbitration, amongst others, given that arbitration thrives on the wheels of confidentiality, and most times these processes are not open to everyone vis-a-vis the traditional litigation court processes.
That's a very good question. So like the Leonard Silk said, mentioning seeking experienced mentors, I would just build on that. If you're able to find a mentor who is willing to accommodate you, how you could have a first-hand experience with arbitration. Sometimes if you're fortunate, your mentor might reach out to the parties, other tribunal members, informing them or asking them if their mentee can sit in. And then it's not cast on stone and iron, in the sense that a party might say no because of confidentiality. They don't want someone to sit in. But there's been a case where a Leonard Silk wrote to the panel and then wrote to the parties and said, a junior in her law firm wants to, sit in just to see how the arbitration hearing would go on during the arbitral proceedings. So there's a possibility, but just know that, most times the parties might say no based on confidentiality, but that's another way someone can sit in and have experience. Another thing is, as a student, you could also look out for international moot sessions. You have moot sessions, conducted by ICC, for instance, and some other institutional bodies, whereby students can participate in moot arbitration trials, and they have judges. So this is another way that you could build, how it works, because even the NICArb, for instance, for their associateship, membership, and fellowship trainings, they have a moot session. And I always encourage participants to, actually participate, because the moot sessions are replicated just the way an arbitral proceeding will hold. So these are ways students can help harness their skills in, the arbitration industry.
Thank you very much, Doctor, and I agree with you completely. So I have a couple more questions, but because of time, this particular question, I will be directing it to Mrs. Oshodi-John, if she's still with us. The question is, how can Nigerian practitioners attract cross-border arbitration opportunities, as the registrar and CEO of the institute?
Thank you, Chidera. That question is, for me, it's almost like leaving primary school and jumping to either the secondary school or the university. So let me start first of all by saying that the starting point is at the national domestic level. You have to have carved a niche for yourself, build your name, at least known to some level within the national or domestic space, the country where you reside or where you operate from. And then once you have been able to do that, and we've heard all that 11.6 and Ifeoma has talked about, once you have been able to do that, then you have to now ask yourself, what is your area of practice? Are you into cross-border? Are you interested in international law? Are you interested in international transactions? You have to ask yourself that question. So if that is your area of expertise, then one thing you can do is to begin to look for professional bodies in the country that you are interested to practice in. For instance, like the Nigerian Institute of Arbitrators, what we have done, because we are not just a Nigerian institute, but we are a Pan-African institute, what we have done is build synergy, collaborations across the African continent. And so we have put the institute out as a Pan-African institute, and if you are a member of NICArb, definitely you have access to some of these regional institutions like ESUMA, the Higher Court of Magistracy for the Ohada region. We have Chamber of Commerce, Arbitration and Mediation for the Chamber of Commerce in Cameroon. We have JCAM. We have Benin Republic Mediation and Arbitration Center. So we have a lot of all these other centers. So once you are doing so well in NICArb, if you're a member of NICArb or any professional body you belong to, then you can also join these other bodies. Go out there, go online, check their websites, look out for what is the criteria to be a neutral part of their panel. And once you fit those, once you are able to meet those criteria, then you can now write to them and you want to be a part of them and join them. But I would advise that before you do that, you must understand, like I think it's Mr. Dapo, Akinosun said, you must understand the culture. Particularly if you remember, Nigeria is surrounded by French-speaking countries. So the nearest cross-border dispute that I think you can assess as a Nigerian will come from Francophone countries. So the next question is, do you speak French? So if you don't understand French, you don't speak French, you need to invest in French. So the issue of language is also something you need to talk about. And then number 3 point I need to talk about, you have to understand you have to understand the laws within those jurisdictions. For instance, in Francophone country, it is a civil law jurisdiction country. So it means that it's not common law. You have to also understand the procedures for civil law. So I believe that once you are able to do all of this, then you are now ready to be able to handle cross-border disputes. Thank you.
Thank you so much, Mrs. Oshodi-John. Thank you once again to all of our speakers. I mean, everybody will agree with me that they really went straight to the point, discussed what matters, and, you know, did not discuss things that were not necessarily relevant. Every single thing they said from the beginning to the end was very, very important, and they did this in, you know, a very, very short period of time. I'd like to thank all of our speakers, Mr. Adebayo Adenipekun, SAN, Mr. Dapo Akinosun, SAN, and Dr. Ifeoma Nwafor. Thank you so much for your time, and thank you for making this session a very, very practical one. And there are a couple of questions that I keep getting, but we cannot take all the questions now because our speakers are very busy and they've generously, you know, given their time to us. So you can, you know, reach out to the Institute or reach out to them on social media, or however it is you can reach out to them to ask them their questions. And I'm sure they'll be very, very willing to, you know, answer your questions. And just to reiterate some of the key takeaways that we have here, as all of them have mentioned, that you need to position yourself properly. You need to stop trying to be everything. You cannot be a master of everything. You have to, find your niche and create expertise in that. And your reputation matters. Always keep that at the back of your mind, that your reputation matters, and visibility create opportunities. Go where appointments are made and learn how to work across, cultures. Be findable, be accessible, build relationships, leverage on technology, give back to the society as well. They have done their bit by giving back to us right now, by speaking to us out of their busy schedule. So give back as well in any way you can. Master your craft and obviously know the law, really. You cannot say you want to make money out of arbitration and you don't know the law. And I'm sure that if we're able to do all of this, it will not take long and our knowledge will translate into profit. Once again, thank you so much to our speakers for their time. Thank you to the Institute for putting together this webinar. And thank you to our audience who have been very, very engaging. And I'd like to say thank you once again and have a very good afternoon.